My name is Julia Santo, and I'm one of the attorneys at Lamson and Kuttner. Today, our founding partner, David Kuttner, is going to be giving a wonderful presentation on advance directives. David is incredibly knowledgeable and a wonderful speaker, so I think you'll all enjoy the presentation. If you have any questions while the presentation is going on, please don't be shy. Put your question in the chat. If you write your question in the chat, I will either respond to it or ask David to answer the question live. Okay, I will be moderating and asking David questions throughout as necessary, and also responding in that chat. So please do make sure that you ask any questions you have. We want to make sure that this webinar is as interactive as possible. All right, so without any further ado, David Kuttner.
Thank you, Julia. As Julia just said, we're going to be talking about advance directives today. Maybe kind of a mundane topic for a lot of people. Oh, I'll get around to it one day. This is really, really important. We consider advance directives to be really foundational in our law practice. It's the first thing we want to take care of for our clients. So it's important, and you're going to hear all about it today. But first, I want to thank PSS for hosting us again. We like presenting here and reaching out to all of you with these important topics. So let's get started. As you can see on this slide, advance directives, like the name implies, allows you to put in place someone who you trust to act on your behalf, your agent. And we can all imagine, although we don't like to think about it, that there are situations where we might need someone to act on our behalf. If we had an accident, if we had a serious illness, if we lost mental capacity, there are really all kinds of situations where we might need the help of someone we trust to act on our behalf. And I think you can see that this is not limited to seniors. Really everyone should have, everyone over the age of 18 really should have advance directives, because none of us can be sure that we will not be affected by an accident, an injury, a serious illness. Incapacity can arrive at any time for any of us. And again, we don't like to think about it, but since it's a possibility, it's a risk that is out there. So let's do something to take care of that risk. And I think if we do, we can have peace of mind about it and be able to go forward. So at the bottom of the screen, you'll see the common types of advance directives, and we're going to talk about all of them today: the power of attorney, the Health Care Proxy, the living will, and the DNR orders. So let's start with the power of attorney. And again, this is a really important document. All of us have a life that involves property, insurance, investments, taxes, financial matters of all kinds, personal matters of all kinds. What are we going to do about that if we're unable to handle these things as we normally do? That's where the power of attorney comes in. And I know from our law practice that with married couples, many assume that they can take care of things for their spouse, right? So, should I be able to just do all of this on my wife's behalf without any authority from her? No, you can't. try writing a check on her bank account or signing papers on her behalf. You have no authority to do that. None of us does. So it's really important, married or not, to think about having a power of attorney. In New York, you can appoint more than one agent if you want to. Oftentimes, people are appointing their children, and you've got two children, there's no need to choose between the two of them. They both can be your agents if they're both responsible people and they have your best interest in mind. Why not? And as we say on this slide, agents are legally required to act upon your instructions. And if they don't have any instructions from you and something needs to be done, they must always act in your best interest. Agents under a power of attorney are fiduciaries. They have a legal responsibility. Again, they must act in your best interest. So just because they have the right to access your bank account, it doesn't mean that they have the right to spend your money for any reason. If they do write a check, it better be for something that is benefiting you. Now, as seniors, this document assumes a particular importance. Oftentimes, we're thinking about applying for benefits under the Medicaid program. In that case, there are a lot of documents to sign, and somebody better have the authority and the ability to do that, or we're not going to be able to proceed. That's just one example, but we can imagine all kinds of things. Tax returns, renewing insurance policies, looking at investments, maybe making changes in our investment portfolio that would be indicated. All kinds of things where we're going to want someone who can act on our instructions, or at least be able to do what's needed in our best interest. So, we had a question, Julia?
Yes.
Okay.
So, one person asks, are there any best interests that are not financially related? So I think the question is about the scope of authority here. Is anything not related to finances?
Well, admittedly, a lot of these things are related to finances, but others of them are not necessarily. Things like employing someone to assist you, maybe an aide in the home, something like that. I think we can imagine other situations. Maybe you have a couple in mind yourself, Julie. I don't know, but
I would say one of the biggest ones would be calling insurance companies on your behalf, making sure that you're getting the benefits that you need. It's really important that your agent has this broad scope of authority, even for things as simple as picking up your mail, right, David?
Yeah, and that's a good example. And Julie is thinking about a case that we had where a daughter went down to pick up her mother's mail at the post office, and there was an important certified letter, and the post office said, well, look, we can't give you this letter. You're not the addressee. And she said, well, yeah, I know. I mean, I'm her daughter, and I have her power of attorney, and I have it with me here. So she pulled out the power of attorney document, and the guy at the post office said, well, okay, that's fine, but show me where in that document it gives you authority to act in regard to the U.S. Postal Service. Well, guess what? It wasn't there. It wasn't defined in the scope of authority granted to the agent, and the post office refused to turn over the letter. And that's one maybe kind of amusing example, but it really wasn't so amusing because it was an important letter, And it took quite a lot of effort to for this person to get her hands on that letter. So it is really important to have a good power of attorney. It's not all financial, but obviously most of it is. But again, anyone who signs a power of attorney, and we're going to look at an actual document in a moment, has an opportunity to decide, how big the scope of authority should be. What am I going to allow my agent to do on my behalf? And that's a decision every person who signs a power of attorney and authorizes an agent will make when he or she signs the document. So why don't we take a look at an actual power of attorney? So,
David,
yeah.
I just want to bring up two more questions that I think you're going to answer, but I'm just going to point them out. Somebody wants to know about whether people should, if they have co-agents or successor agents, if they should act jointly or separately. I'm sure you're going to go over that. And then someone also wants to have you go over the best way for an agent to sign a check or document for a principal.
Okay, we're going to take a look at that in a moment, both of those.
Thanks.
All right, so this is the so-called New York statutory short form. It really isn't very short, but it could be a lot longer. And I will show you in a moment why and where. So you can see on the first page here that if it's your power of attorney, you will be appointing your agents. And again, you can name one here, or you can name two, or if you want more than two, you can do that also. So moving on, and we'll get to the first question that you asked. If you had designated more than one agent, you're going to have to indicate it, that you can see on the top of this form whether your agents are allowed to act separately or whether they're going to be required to act jointly. So there are pros and cons to this decision. Obviously, logistically, it's often convenient and possibly much more convenient to allow agents to act separately, particularly if they live in different cities or long distances from each other. If they have to act jointly, then every time they do anything, whether it's signing a check or signing any document, they're both going to have to sign. So it's not just a matter of sort of checks and balances that they agree with each other. There's a logistic component to it here. On the other hand, if we allow them to act separately, then we're opening up the possibility that one of them might do something that the other might disagree with. I think looking at what's happened in our firm and the hundreds or thousands of powers of attorney documents that we have prepared and supervised the execution of for clients, I would say they almost always allow agents to act separately. I think if you have two children, I guess there's always a possibility that they'll disagree about what is mom or dad's best interest, but I don't know, I haven't really seen in our practice, at least, that kind of disagreement come up or cause a real problem. But, nevertheless, for anyone who does like the idea of joint action and eliminate the possibility of one agent acting in a way that the other agent really disagrees with, we can go with joint action. You can see here in the form that you can designate successor agents, if you wish, and I think it's always a prudent thing to do to appoint a successor. Something can happen to an agent just as it could happen to any of us. So if for some reason our agent should become incapacitated or unable, or for any reason be unavailable to serve as agent, then we want to have a successor who we have chosen. So now looking a little bit further in the form at section F, grant of authority. And this is why it's called the short form, by the way, because you can see here that each of these categories, real estate transactions, chattel and goods transactions, bond, share, and commodity transactions, etc. These are all matters that are defined in New York law under the New York General Obligations Law. So the New York short form has omitted the definitions that we can find under the General Obligations Law. But I think we all basically understand, if we're talking about real estate or banking or insurance and so on, what it is that we're talking about. So if you're signing a power of attorney, you can choose among these subjects and authorize your agent to act in some of them, but not others, if you want to do that. Or, as you can see, if we go down to the letter P, we can authorize the matters collectively. So we can say we can put our initials at the letter P and say each of the matters identified by the following letters, A through O, if we want to authorize our agent to act with respect to each of these matters. So again, it's a choice. I think in most cases, it's a good idea to authorize your agent to act regarding all of these matters. Again, none of us knows exactly what's going to come down the road for us, and we find it's best that agents have authority to act come what may, if we're unable to act ourselves. All right, so moving on to the next section of the power of attorney, called certain gift transactions. So gift transactions are not necessarily limited to birthday gifts and holiday gifts. What we're really talking about in this section is transferring ownership of money or property that you own. Are you going to give your agent the authority to do that on your behalf? So I guess your question might be, well, why would I want to do that? Well, this comes up regularly in matters where someone needs to apply for government benefits, and particularly Medicaid. And I'm mentioning this, and I don't want to spend a whole lot of time talking about Medicaid and long-term care, but all of us are exposed to the risk of needing long-term care. And if we should need it, it's very, 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 very expensive. And in order to qualify for the Medicaid program, which pays for long-term care on our behalf, and for which we've paid a lot of tax dollars, each of us, to support, if we want to qualify, we may need to transfer ownership or make gifts of some of our money and property. And If we're not able to do that because we're incapacitated, it would be nice to have our agent have the ability to do it for us. And so if the agent were to make a gift or transfer of our money or our property for the purpose of allowing us to qualify for a significant benefit, that might well be an action taken for our benefit and in our best interest. So that's really most often where this gift transactions authority comes into play. It can be a very, very important one, particularly for seniors who are facing the long-term care issue sooner rather than later. So moving on to the next section, modifications. So here, anyone can add any additional powers granted to the agent, and you can see it's optional, so you don't have to. For our clients, we typically add a lot of modifications, actually several pages of modifications, because we have found in our practice where we're representing seniors, and oftentimes, again, these seniors are facing the long-term care issue, among other things. There are a whole lot of other useful powers to grant to your agent. And by the way, if we grant a power, it doesn't necessarily mean that it's ever going to be used. But if it isn't used, it causes no harm by being in the document. On the other hand, if a particular power is needed and it's not there, that can cause a real problem. So, at least in our view, for our clients, we want to include all the powers that conceivably could be useful for that client. And again, that's typically a lot of additional optional powers.
David?
Yeah.
I have a quick comment and then question.
Okay.
First, I just want to point out to everyone that this is not a power of attorney that we prepared. This is the short form, the New York State standard short form. So somebody had asked where certain powers are that we were discussing earlier. David just explained those would be under the modifications section, unless you see an attorney like an elder law attorney that knows what kind of additional authority should be in the document. Your standard form will not contain any of those powers. And then the question, David, is, can siblings fight this document? For example, the parent chose one child and later the excluded child finds out and is not in agreement with the decisions that have been made by the chosen child.
Well, that would be unfortunate. And we certainly don't like to see that happen. If the child who wasn't chosen wants to challenge the power of attorney, it's possible to do that. And you know, in all my years of practice, I guess I've seen that happen once or twice, maybe, but it doesn't happen very often. I think what would have to happen is the child who wants to challenge the power of attorney would have to make an argument that the parent lacked sufficient mental capacity to sign the document. And before making such an allegation, you'd want to have some evidence of that. Certainly your attorney who would be filing a complaint or seeking a guardianship would want to see evidence of that nature before making that kind of allegation. And, all of us should bear in mind that parents really owe no legal obligation to their children once children become adults, right? So you have, as a child, you have no right to be an agent under a power of attorney. You have no right to a share of the estate. So if a parent chooses one child and excludes the other, presumably it's because the parent thought that the quote unquote chosen child was the one who was more reliable and more responsible. It didn't mean that the child who wasn't chosen was not loved by the parent. I'm sure that, oftentimes as parents, we can say we love all of our children equally and mean it, but at the same time, we can recognize the abilities and qualities of our children, and some are more capable than others.
And David, just to quickly jump in here, the person that's quote unquote like fighting the power of attorney would need to retain an attorney, and that would have to go to court. And to combat this, one thing that I would just say is really important is to have an attorney there that is executing this document with you. And that's because the attorney is going to make the decision at the time of signing whether or not the principal has the capacity and understanding to sign the document. And it makes it a lot more difficult for the complaining child and their attorney to say that the parent didn't have capacity, when an attorney in front of a notary and 2 witnesses agreed that the principal did have capacity at that time.
Yeah, and that's a good point, Julie. It's that's another reason why it's pretty difficult to challenge these documents, is because not only is the parent signing it, but he or she is signing it in the presence of a notary public and 2 witnesses. And the reason why all of those folks are there to witness the signing of the document is so that there are people who can attest that the person who signed the document knew what they were doing when they signed the document. So it's a real uphill battle if you want to challenge a power of attorney. I would be cautious about proceeding with that kind of thing. All right, so moving on, we have a possibility of naming a monitor to kind of look over the shoulder of the agents. We don't generally recommend that. I think that the best practice is to choose an agent or agents who you are confident are trustworthy and have your best interest in mind. As you can see, agents are entitled to compensation. Or rather, they're entitled to reimbursement of expenses. They may also be entitled to compensation if you want to compensate them. Typically, when family members are serving as agents, they're not asking for or receiving compensation. So powers of attorney are documents that are revocable. So that means if you change your mind about the document and you want a different agent or agents, you can always revoke the document that you signed and do a new one. No problem there. The power of attorney is terminated by death. So if you die, your agents have no authority to do anything on your behalf after you have passed on. So once this document is reviewed and you are in agreement, you would sign the document in the presence of the notary public and, as already indicated, in the presence of 2 additional witnesses. And here we come to something that's, I think, awfully important, both for the agent or agents and for the principal who's granting the powers. So it's good to know that, I think, as I've already said, the agent must act according to instructions from the principal. Or if there are no instructions and something needs to be done, the agent needs to act in the principal's best interest. We want to avoid conflicts of interest. We want to keep as an agent, we want to keep our property separate and distinct from the principal's assets. We want to keep a good record of any transactions that we have engaged in on behalf of the principal. And finally, we want to disclose our identity as agent. And this is really important, both for your principal and for yourself as agent. You don't want to be engaging your own responsibility and liability. For instance, you're signing your mom or dad into a nursing home and you're signing an agreement with the nursing home. You don't want to be responsible for that bill, which is accumulating at $500 a day. So if you're going to sign that document or any document, you're going to sign your principal's name by your name as agent. And you're going to say as agent, so that anybody who looks at that document knows that you signed it on behalf of your principal, acting as that person's agent. So if I'm acting as agent for someone, let's call that person John Smith, okay? So if I'm John Smith's agent and I'm signing a document, any document, a check, a tax return, a contract, doesn't matter what it is, I am going to sign John Smith by David Kuttner as agent. And that makes it clear that I am engaging John Smith's responsibility here, not my own. I am acting for him as his agent. Okay, I think we're ready to move on. Any further questions about the power of attorney, Julia?
No, you did a very excellent and thorough job.
Well, thank you. Oh, sorry, I was getting ahead of myself here. So the agent also has to sign the power of attorney document in front of a notary. And by your signature as agent, you are acknowledging the responsibilities that we were just talking about, that are listed here under important information for the agent. So you are acknowledging your legal responsibilities when you sign this document in front of a notary public. All right, next topic is our Health Care Proxy. And this is a little bit different than the power of attorney because it concerns medical care and health care. So if we are incapacitated and unable to express our wishes and our decisions regarding our health care and our medical care, we can appoint someone to express our decisions for us. And I think you can see that this is a little bit different than the power of attorney because the power of attorney does not require that the principal be incapacitated. The principal may become incapacitated, but once that document is signed, the agents are authorized to proceed immediately. With the healthcare proxy, it's different. If you are able to express your wishes and your decisions for yourself, your healthcare agent does not have any authority to act on your behalf. It is only when you are unable to express your own decisions and your own wishes for yourself, that's when we need the healthcare agent. And in New York State, we can have only one agent. So sorry if you're the excluded child and mom or dad has chosen your sibling or somebody else to act as agent. That's required in New York State. We can only appoint one agent at a time. We can appoint an alternate agent to take over if the primary agent is unwilling or unavailable or unable to continue to act as the healthcare agent. So again, we have a successor or alternate agent. So I think what's most important about the healthcare proxy is if we are the healthcare agent, we really need to know what the wishes are of the person for whom we are acting. What would mom or dad or whoever it is that for whom we're acting, what would they want to be done? And, just a quick personal story, and I was confronted with a situation myself as my mother's healthcare agent. And there was a time in her life when she was hospitalized and she had pneumonia and congestive heart failure, and they put her on a ventilator. And one day when I was there to visit her in the hospital, a couple of doctors were there and nurses, and they started to tell me that, look, you don't want your mom living her life on a ventilator, and this is really awful. And as the healthcare agent, you really need to think about pulling the plug here, because this is really, nobody wants to live that way. Well, I said to them, my mother's always been a fighter, and maybe there'll come a day when we need to address that issue, but not right now. I want to give her a good and fair chance to come out of this. I think that's what she would want. So that's what we're going to do. And that was my decision as her healthcare agent. Well, a couple of weeks later, she walked out of that hospital and lived for quite a while afterwards. So again, I think it is really important to know the wishes of the person for whom you are acting if you are a healthcare agent. Okay, any questions about the healthcare proxy, Julia?
So there's a question that is a very good one about advance directives. So every state has different forms and rules, right? So some states say you don't need a notary, but you just need 2 witnesses. New York says you need a notary and 2 witnesses. What happens if a person moves? Will the New York power of attorney and healthcare proxy be accepted elsewhere? And also, as a follow-up, somebody says, do I need a lawyer?
Well, as to the first question, I can't really speak for most states or really other states. We're New York lawyers, and not having a practice in other states, even ones as close as New Jersey or Connecticut. we really shouldn't be speaking about their laws, but I think as a general matter, in law, there's something we call comity between states, where states will respect the laws of other states. And I would expect that a New York power of attorney or a New York healthcare proxy would be recognized and valid in most other states, I would think. By the way, in New York, as I've already said, we can only appoint one agent. Other states like Florida, for example, allow multiple agents, but that would not work in New York. We can only have one agent. And when we sign the document in New York, we actually don't need a notary for the healthcare proxy. We need 2 witnesses when we sign a healthcare proxy. There is a form that is published by New York State Department of Health, and I think it's a perfectly acceptable form. If you're in a hospital, they're probably going to give you one to sign if you don't already have a power of attorney. In our law firm, we have our own healthcare proxy document, and we think it's a little bit better. I think it clarifies some points about the agent having access to your medical information if he or she is making a decision on your behalf. But to answer the question, do you need a lawyer for this particular document? I don't think that it's necessary. Do you need a lawyer for the power of attorney? I think it's recommended because the scope of authority under a power of attorney is so important. And, we have seen in our law practice many occasions where somebody had a power of attorney. Sometimes, by the way, these power of attorneys were not even valid because somebody signed a form that was no longer the proper form, because our laws in New York have changed a few times over the years, and different forms and different information is required and has changed. But let's say we have a valid document. If that document does not have an adequate scope of authority, it may prove to be useless in a given situation. So that's where those modifications come in. We give a lot of thought to the modifications that we include in our power of attorney, because we know there may be, and in many cases it's predictable that there are likely to be the need for those modifications and the additional powers. So again, not necessary to have an attorney, but I would say it's recommended if we're looking at a power of attorney.
Highly advisable.
Okay. So let's take a look now at our living will. And as I say there in the first line on this slide, it's attractive in concept, but can be challenging to apply in practice. And, again, the idea of the living will is this. I really don't want to have to appoint a healthcare agent because then I have to rely on that person's judgment and ability to express my wishes for me. I would rather just write down my wishes so that it's clear and unequivocal what I want. And so that's the idea of the living will. And admittedly, that is an attractive concept. If it were possible for us to prepare a document that is clear and unequivocal about what we want for our healthcare and medical care, I agree that would be a good thing. But in practice, I really challenge anyone to make a clear and unequivocal statement about what we want. So take a look at this document. And by the way, this is not the entire form, but I think it's the main part of the New York State standard form of a living will. So here we can see that, I do not want cardiac resuscitation. I do not want mechanical respiration. I don't want artificial nutrition and hydration. I do not want antibiotics. Okay, well, all of that is perfectly clear and unequivocal, but the question is, under what circumstances do I not want antibiotics or artificial nutrition and hydration? Because obviously, if I don't have any of the things on this list, I'm just going to die, right? So if that's my choice, we want to know under what circumstances are we not going to give someone artificial nutrition and hydration or cardiac resuscitation and so on. Well, here's what the standard form tells us. We would do that when the treatment merely prolongs my dying. Well, how clear and unequivocal is that? Do we know whether the treatment is merely prolonging my dying? Well, probably every glass of water or every meal that we drink, every glass of water we drink or every meal we eat is in some sense prolonging our dying. So look, I just think that kind of trigger really isn't all that helpful. So here's the rest of it. If I should be in an incurable or irreversible mental or physical condition with no reasonable expectation of recovery. Well, if we put 3 doctors in a room, would they all agree on that? If we put our 3 children in a room, would they all agree on that? I don't know. I think it's, again, a trigger that requires judgment. So we really are not getting away from the issue of giving someone the ability to make a judgment by having a living will instead of a healthcare proxy. And what happens if we have both? Well, in that case, if we have 2 or more children, as an example, one of the children who is not the healthcare agent under the healthcare proxy could use the living will to challenge the decision of the healthcare agent. And we've actually seen that. There have been cases in court that arose in that way. So I don't know. I am not particularly in favor of living wills. I don't think they really provide what they supposedly are providing. Again, something, in my opinion, that is attractive in concept, but really doesn't work all that well in practice. Okay, any questions about living wills, Julia?
No, I think I just wanted to super quickly mention that there was just a New York Times article that talked about how people do change their mind as well as they age, and a living will really nails you down, and you don't know how your philosophies about treatment are going to change as you age. So I just wanted to point that out.
Right, and if you have this document and your opinion has changed, but you have neglected to rescind it or write a new one, um, somebody may be trying to apply your living will when it really is not, does not express your wishes anymore. And it also may not account for, um, changes and developments in the medical profession, because things are happening all the time, and improvements are happening all the time. Um, just as an example, surgeries that used to be open surgeries where they'd be cutting you open with scalpels are often done today arthroscopically, where they just, there's a little pinprick and they're going in and doing it, all of it in a much more efficient and safer way. So all kinds of developments like that all the time in medicine.
Yeah.
Anyway,
Sorry, can I just do one more super quick example? This one I really like because during COVID, I don't think any of us could have foreseen that so many people would be on ventilators, right? And I've seen some living wills that said, I do not want to be on a ventilator under any circumstances. Maybe a ventilator was necessary to recover from COVID and you could have walked out of the hospital in a month, right? So just things to consider.
all right, so let's take a look at our DNR, do not resuscitate. This particular one is, again, a New York State form from the Department of Health. We also have in-hospital orders to not to resuscitate. But I think what's important here is you as the person for whom the order applies cannot create this by yourself. You need a doctor or nurse practitioner or physician assistant to sign the form. All right, this is a medical form, so it's something that you would need to discuss generally with your doctor and express your desire to have this order made. And I guess if the doctor agrees, he would sign it and put it into effect. You can see that it needs to be reviewed within every 90-day period. And I think, although it's not stated here on this form, which is really, this slide, which is an excerpt of the form, I think if you're developmentally disabled, then the form must be signed by a doctor. It cannot be signed by a nurse practitioner or a physician assistant. Again, the DNR is an order made by a doctor, not by you. Okay, so one more point here, the Family Healthcare Decisions Act. So if we do not have a healthcare agent, this act allows someone else to make a decision for us. That person is called the surrogate. And under the Family Healthcare Decisions Act, one of the persons listed here in the act, I guess the first choice is the guardian, and if there is no guardian, then the spouse, and if there is no spouse, then an adult child, and so on. So we do have the Family Healthcare Decisions Act. If it's brought into play, obviously, you are not the one choosing the surrogate. The act is choosing the surrogate for you. And the reason that's happening is because you are incapacitated. I think the lesson here, at least to me, is I'd rather choose my own healthcare agent and have it be the person who I feel I can rely on to express my wishes and someone who actually knows my wishes. Because even though this act allows for the appointment of a surrogate, that person doesn't necessarily know anything about what my wishes are. All right, so why are advance directives important? Well, I think we've seen why they're important. They allow you to name someone who you trust and who you want to be there for you to express your wishes and to deal with your money, your property, your tax return, your whatever on your behalf if you're unable to do that yourself. And as you can see, as we've said here, more importantly, the power of attorney and healthcare proxy will normally avoid guardianship. And again, guardianship is one of those things that sounds pretty good in concept, but I think in practice, it doesn't work as well as it is made out to be. The law, New York law, allows for the appointment of a guardian. And that person in the guardianship proceeding is called the alleged incapacitated person. And a court proceeding is engaged to determine whether the alleged incapacitated person is in fact incapacitated. And that means court hearings and appointment of an evaluator to come in and look. It may mean expert witnesses. It may mean the testimony of the person who was alleged to be incapacitated, and so on. And then the court will ultimately make a decision about whether a guardian is needed, and if so, the court will appoint a guardian. That guardian will not necessarily be the person who you would have chosen to take care of these things for you and manage your property and financial affairs and make medical decisions on your behalf. But if it comes down this way, you're going to be stuck with the person that the court appoints. And meanwhile, all of what I have just described is being paid for by you. And it's one of the things that I find personally just concerning about many guardianship proceedings is they are supposedly looking to protect someone who is alleged to be incapacitated, and meanwhile we're spending all their money to find out, and at the end of the day there's very little left to protect because it's all gone to evaluators and expert witnesses and lawyers. So at least the way I like to advise a client is, let's have a good power of attorney and a healthcare proxy. And one of the things that we can avoid is the guardianship proceeding, because if we have a good power of attorney and a good healthcare proxy, there's really no reason for a guardian. And it's very unlikely that one would be appointed in such a circumstance. So our advance directives, our power of attorney, and our healthcare proxy allow agents who we have appointed to make the decisions for us. We avoid the time-consuming and the time and the expense of the guardianship proceeding, and I think that's really the best solution here. So I think we have a minute or two for any further questions, but I believe that's the end of our presentation today.
Oh, David, did we not mention a MOLST form. We just had a question about that.
Oh, yeah, why don't you go ahead on that, Julia?
Okay, so that's medical order for life-sustaining treatment form. You're going to want to do that with a doctor as well. I know we don't have a ton of time, but basically it's for patients with serious health conditions who may pass away within the next calendar year, and you're in a long-term care facility. So that's when you would be able to do a MOLST form.
Yeah, it's a little bit like your DNR. It does
Yeah.
need to be signed off by a doctor. So these are kind of end of life situations that might be appropriate for a DNR or a MOLST form.
Exactly. Well, thank you very much, David. It was a really excellent presentation, and thank you again, Lori, for having us.
Thank you so much. We always appreciate your wisdom and the time that you share with us. So thank you all for coming. Pieces of this will be appearing on the PSS YouTube channel, so you could stay tuned for that. And I wish you all a good day. Bye-bye now.